This is LXPN TV, and I'm Colin O'Keefe. In today's episode, we're taking a look at two employment lawsuits involving a certain racial epithet, the N word. Joining me to share his thoughts on the two cases and offer lessons that employers can learn from them is Daniel Bernick, attorney in Birmingham, Alabama, with Sorority & Permit, and author on the Alabama Employment Law Report. Daniel, first, can you tell me a bit about the first case that you recently wrote on, one coming out of Alabama State University?
Well, Colin, I appreciate you having me on. Before we get there, I just want to point out that this is the 50th anniversary of the 16th Street Baptist Church bombing here in Birmingham back in 1963. So the city of Birmingham's in a week-long remembrance and celebration of the achievements we've made since then. So it's kind of ironic that we're here talking today about what you would have thought would have happened back in the 1950s and 1960s. The first case involves Alabama State University, which is a historically black university here in Alabama, in Montgomery. There were three employees, female employees. Two of them were African American, and one of them was biracial, half African American, half white. All three were employed at ASU and worked under the direction of John Knight and Levonette Barkley. Mr. Knight served in several positions with ASU, including acting president, assistant to the president, and chief operating officer. He is also was and still is a member of the Alabama State Legislature as a representative from the Montgomery area. Ms. Barkley was the associate executive director in the office of special assistant to the president, so she worked with Mr. Knight. When you look at the claims that are made, the claims are basically racial harassment, sexual harassment, hostile work environment, and retaliation. If you want a textbook case of what not to do in the workplace, this would be it. Before I start, I just want to read briefly from the opinion to give some background and feel for this case and what the 11th Circuit Court of Appeals gleaned from the record that they had. Judge Dubina starts his opinion by writing, quote, "The facts of this case should greatly concern every tax-paying citizen of the state of Alabama, especially because it involves a public institution largely funded with tax dollars paid by the people of Alabama." And his first footnote is, quote, "We apologize for the offensive and demeaning language contained in this opinion, but such language comes directly from the trial record." I'm not going to get into the explicit language, but obviously there was allegations and a jury verdict finding that the use of the N-word and various forms of the N-word were used over a 7-year time frame. A lot of cursing going on in association with the use of the N-word, a lot of degrading and insulting of the employees by these two individuals. Just two examples of what we're talking about. One of the plaintiffs' 7-year-old son was at the office one day, and Miss Barkley called the son the N-word, which led to him crawling underneath his mother's desk and curling up into the fetal position. Miss Barkley also, when the biracial employee advised her that she was biracial, the testimony was that Miss Barkley curled up her nose, looked down at her, and walked away. And also, there were references to breasts as melons, derriere as ham. Miss Barkley would rub up against some of these the female employees, would also place her breasts on the shoulders when they're sitting working at the desk. So it was some pretty serious stuff. Mr. Knight also made some statements such as he liked his coffee sweet like one of the plaintiffs, and he liked it the color of her complexion. He also advised employees not to document the complaints they had and only to report to him verbally and not to HR. He also was quoted as saying, "I am not going to walk on eggshells around my office. Nobody can tell me how to run this office." He threatened employees. He threatened these three plaintiffs. He also threatened other employees about cooperating with the EEOC, and they would be terminated if they did. HR refused to allow some of the complaints to be made. The complaints they did accept were not investigated, and ultimately, two of the plaintiffs were terminated. One of them was terminated by Mr. Knight, after she was off work for a week on sick leave with the doctor's note. And when she came back, he made the decision to terminate her for abandonment of her job. A second employee was terminated after she sent a letter to Mr. Knight with copies to the EEOC and the HR, and she was terminated. The third one was transferred, and this resulted in three verdicts: $392,000, $376,000, and $309,000. And just to conclude, again, to quote the conclusion of the opinion, because I think I can't say it better than the court can, but, quote, "We are left to speculate who is in charge at ASU. Regardless, however, we are unnerved by the apparent acquiescence to, if not outright condoning of, the abusive work environment created by its high-level employees. Such conduct simply has no place in a work environment, especially at a publicly funded university." That's the Alabama.
I see. And second, you wrote about a case coming out of New York City. Can you tell me a bit about what's going on there? What's involved?
It's similar. It's similar because you had a African American female employee who was working for an African American supervisor who's of Puerto Rican descent, and Mr. Carmona is the name of the individual, and he grew up in New York, had a rough life. He was a drug addict. He had an arrest record, but he ended up forming a company or nonprofit called Strive East Harlem, which helps helps people who had difficulty finding jobs find jobs. And since 1984, he's helped 50,000 people find jobs who otherwise probably would not have gotten jobs. So Miss Johnson's working there, and Mr. Carmona goes into a tirade into her unprofessional conduct, her unprofessional dress, and uses the N-word 8 times. Miss Johnson tape recorded this tirade. I'm not sure why she did or why she had a tape record, but it was tape recorded. The jury came back with a $280,000 verdict against Mr. Carmona for that. And that's what the New York case is about. It's probably going to go up on appeal. It's just that's the verdict out of the courts in New York probably a week or so ago.
I see. And lastly, what are the lessons here for employers? Obviously there's some major warning signs here, but what, in your words, should employers take away from this?
In my words, it is when you come up to a railroad crossing, it's stop, look, and listen. The same thing happens in the employment context. The HR department needs to be able to stop, look, and listen, and see what's going on around them. When they have complaints of an acting president and his executive director using the N-word, whether they're black, white, Hispanic, whatever the case may be, that needs to be taken seriously. Same thing in New York. I'm not sure what type of HR department they had up there, but people have to be trained to report these. The HR department at ASU didn't investigate, so they need to investigate. So HR needs to be trained, and should there be a finding of improper conduct, you have to take prompt disciplinary action, which could include termination, suspension, sensitivity training, whatever the appropriate remedy is.
Definitely. These are two interesting cases, and the one out of Alabama State University is especially troubling. So HR personnel need to keep an eye out, and of course the managers, the bosses here, just can't do things like this. Once again, that was Daniel Bernick of Sorority and Permit. For more of his analysis on these two cases, be sure to visit alabamaemploymentlawblog.com, and of course, come visit us at lxbn.com for more of these LXBN TV video interviews and curated commentary from the LexBlog Network's more than 8,000 members. Thank you for joining me today, Daniel.
Thank you, Colin.